A routine traffic stop rarely becomes a national conversation. Flashing lights. A vehicle pulls to the side. An officer approaches the window. Identification is requested. A citation may be issued. And in most cases, the encounter ends within minutes. But when the driver behind the wheel is a sitting federal judge, the situation suddenly feels different. Not necessarily because the law changes, but because public perception does. Here's the question that immediately follows. When police pull over a federal judge, does the Constitution treat them exactly the same as any other citizen? Or are there legal nuances most people don't understand? Let me know your perspective in the comments below. To understand this scenario properly, we need to begin with first principles. Under the United States Constitution, federal judges are appointed under Article 3. They serve during good behavior, which effectively means lifetime tenure unless impeached. This structure exists to protect judicial independence, to ensure that judges can make decisions without political pressure. But judicial independence is not the same as personal immunity from everyday laws. Traffic enforcement falls under state police powers. States possess general authority to regulate roadway safety, enforce speed limits, and conduct stops based on reasonable suspicion. That authority flows from the 10th Amendment and long-established public safety doctrine. The constitutional standard for initiating a traffic stop was clarified in the Supreme Court case Warren v. United States in 1996. In that decision, the court held that if an officer observes a traffic violation, even a minor one, that observation provides sufficient legal justification to conduct a stop. Importantly, the court emphasized an objective standard. The officer's subjective intent does not invalidate the stop as long as there was an observable violation. That principle applies universally. The Constitution does not carve out exceptions based on occupation. If a federal judge fails to signal a lane change, exceeds the speed limit, or violates a traffic control device, the legal authority to initiate a stop exists under the same standard that applies to any other driver. So where does the complexity arise? It arises in perception, discretion, and constitutional structure. Federal judges are members of the judicial branch. Most traffic stops are conducted by state or local executive branch officers. In theory, this is an interaction between two branches of government authority. In practice, however, it remains a standard enforcement encounter governed by the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures. A traffic stop qualifies as a seizure under constitutional doctrine. Therefore, it must be reasonable. Reasonableness is determined by whether the officer had reasonable suspicion of a violation. Now consider the next layer. Judicial immunity is often misunderstood. Judicial immunity protects judges from civil lawsuits for actions taken in their judicial capacity. This doctrine was reinforced in cases such as Stump v. Sparkman, where the Supreme Court emphasized that judges are shielded from civil liability when performing judicial acts, even if those acts are alleged to have been done improperly. But driving a vehicle is not a judicial act. Issuing rulings from the bench is a judicial act. Presiding over hearings is a judicial act. Interpreting statutes is a judicial act. Operating a motor vehicle is not. Therefore, judicial immunity does not apply to routine traffic enforcement. There is no federal statute granting federal judges blanket exemption from state traffic laws. There is also no constitutional clause placing them beyond ordinary policing authority while engaged in personal conduct unrelated to their official duties. Now, let's introduce a realistic educational scenario. Imagine a federal judge is pulled over for speeding. The officer approaches. The judge identifies themselves as a member of the federal judiciary. At that moment, the officer faces a professional decision. The law remains the same, but discretion becomes relevant. Police officers often exercise discretion in issuing warnings versus citations. That discretion exists for all drivers, not only judges. One interpretation is that equal enforcement demands no special treatment whatsoever. Another perspective suggests that professional courtesy, if extended, must be grounded in the same discretionary standards applied to other individuals in similar circumstances. The Constitution does not require either outcome. It requires legality. Now let's discuss escalation scenarios. If the stop remains routine and no arrest occurs, the constitutional analysis remains straightforward. But suppose the situation escalates. Suppose the officer suspects impairment and initiates a DUI investigation. Field sobriety tests are requested. Breath testing is considered. At that stage, the same Fourth Amendment standards apply. Probable cause would be required for arrest. Chemical testing laws would apply according to state statutes. Again, there is no automatic judicial exemption. However, Arresting a sitting federal judge introduces institutional sensitivity, not legal immunity, institutional sensitivity. This distinction matters. The arrest of a federal judge could trigger internal judicial review, public scrutiny, and potentially political implications. But constitutionally, the standards remain unchanged. Now, let me pause here and offer clearly labeled commentary. In my view, the strength of the American legal system lies precisely in moments like this. If the law bends for status, it weakens for everyone. But if enforcement is professional, restrained, and grounded in constitutional standards, the system reinforces itself. Public trust depends not only on equality before the law, but on visible fairness in how that equality is applied. Now let's consider historical precedent more broadly. There have been documented instances where judges at various levels, state and federal, have faced criminal investigations or traffic-related legal issues. In each case, the legal analysis did not center on their judicial title. It centered on evidence, statutory law, and constitutional safeguards. The separation of powers doctrine does not insulate personal conduct from state criminal law. Instead, it protects institutional independence within official functions. If a federal judge were stopped and believed the stop violated constitutional standards, they would have the same legal remedy available to any citizen: suppression motions, civil rights claims under 42 U.S.C., § 1983, where applicable, or federal review mechanisms depending on jurisdiction. The law provides mechanisms. It does not provide automatic immunity. Now consider public reaction. When news headlines read that a federal judge was pulled over, social media often divides instantly. Some assume favoritism, others assume targeting. Few pause to examine the constitutional framework. That reaction highlights something deeper about civic understanding. Traffic stops are legally simple, but emotionally charged. They represent direct state authority exercised against an individual. When the individual holds institutional authority, tension feels amplified. But the constitutional question remains the same. Was the stop supported by reasonable suspicion? If yes, it stands. If no, it may be challenged. No more, no less. As we continue this analysis, we'll examine hypothetical legal arguments both for and against enforcement actions in such a scenario. We'll explore due process protections, examine potential suppression issues, and analyze how federal oversight mechanisms could theoretically intersect. And I want to ask you another question to think about as we move forward. Do you believe public officials experience stricter scrutiny during law enforcement encounters, or more leniency? And what evidence supports your view? Share your thoughts below. In the next section, we'll dive deeper into separation of powers doctrine, federal supremacy considerations, and how constitutional safeguards function when government actors interact with one another outside their official roles. As we continue examining this incident, it becomes important to understand something many people overlook. When a law enforcement officer initiates a traffic stop, the legal framework guiding that interaction does not change based on who is sitting behind the wheel. The Fourth Amendment standard remains the same. The requirement for reasonable suspicion remains the same. The obligation to behave professionally remains the same. However, the public reaction does change, and that reaction often reveals more about our perceptions of authority than the event itself. According to publicly available legal standards, federal judges, while highly respected judicial officers, do not possess immunity from ordinary traffic enforcement. Judicial immunity, as established through long-standing precedent, protects judges from liability for acts performed within their judicial capacity. It does not extend to personal conduct unrelated to court duties, such as driving on a public roadway. This distinction is crucial. Judicial immunity protects decision-making in court. It does not create a shield from standard law enforcement procedures outside the courtroom. That's an important legal clarification. Now, when analyzing a traffic stop involving any high-profile official, two legal questions often emerge. First, was the stop supported by lawful justification? Second, was the interaction handled in accordance with constitutional protections? Under Supreme Court precedent such as Wren v. United States, an officer may conduct a traffic stop if there is probable cause to believe a traffic violation has occurred, even if the violation is minor. The court held that the subjective motivations of the officer do not invalidate an otherwise lawful stop supported by objective probable cause. That means even a small infraction, such as speeding slightly above the posted limit, can legally justify a stop. From an educational standpoint, this principle applies equally to all motorists. But here's where things become more nuanced. While the legal threshold for initiating a stop may be relatively low, the manner in which that stop is conducted must still comply with constitutional boundaries. The stop must not be unreasonably prolonged. The officer must not conduct searches without consent, probable cause, or a valid warrant unless a recognized exception applies. This is where the analysis shifts from, was the stop lawful, to, was the stop handled lawfully? And that distinction matters. In public discourse, many discussions focus immediately on status. Why would police stop a federal judge? But legally speaking, that is not the correct starting point. The correct starting point is evidence. Did a traffic violation occur? Was there documentation? Was the interaction recorded? Were procedures followed? When evaluating any encounter involving public officials, transparency becomes essential. Body camera footage, dash cam recordings, written citations, and official statements all contribute to the factual record. Without those, speculation fills the vacuum, and speculation rarely produces accurate conclusions. Now, let me share my perspective here, clearly labeled as commentary. In my view, incidents like this serve as powerful reminders that the rule of law is strongest when applied consistently. If officers treat a federal judge the same way they would treat any other citizen, respectfully, professionally, and within constitutional limits, that reflects institutional strength. But if either side appears to leverage status or authority improperly, public confidence can erode, and confidence in the justice system is foundational to democratic stability. This is not about personalities, it's about principle. Another educational point often overlooked is the concept of de-escalation. Modern policing standards increasingly emphasize communication, clarity, and calm procedural interaction during traffic stops. Many departments across the country have implemented policies designed to reduce tension and enhance safety for both officers and drivers. In high-visibility situations, those standards become even more important, because perception influences legitimacy. When reviewing such incidents, courts typically examine objective factors. What did the officer observe? What did dispatch records indicate? Were policies followed? Intent is often far more difficult to prove than conduct. And in legal proceedings, conduct is what matters most. If any citation was issued, it would typically proceed through the same judicial channels as any other traffic matter, unless dismissed or resolved through lawful procedures. There is no automatic exemption based on judicial office. Now, another dimension to consider is ethical responsibility. Federal judges are bound by codes of conduct that emphasize integrity and public trust. While those codes primarily govern judicial behavior, public interactions can still influence perception of impartiality and professionalism. Likewise, police officers are bound by departmental regulations and constitutional obligations. So in a scenario like this, both sides represent institutions larger than themselves, and that heightens scrutiny. From an educational standpoint, it is also important to understand what does not automatically make a stop unlawful. Discomfort, surprise, public attention. None of these factors determine legality. Courts focus on whether constitutional standards were met. If video evidence exists, it often becomes central in public interpretation. However, short clips can lack context. Courts review full recordings, dispatch logs, timestamps, and documentation, not just viral excerpts. This is why legal analysis differs from social media reaction. One asks, is this shocking? The other asks, is this constitutional? And those are very different questions. Let's talk briefly about procedural safeguards. If a driver believes a stop was improper, there are legal remedies. Motions to suppress evidence, internal affairs complaints, civil rights lawsuits under 42 U.S.C. per 1983, or administrative review processes may be available depending on circumstances. However, each requires evidence. Courts rely on documentation, not assumption. And again, this discussion is for informational purposes only and not legal advice. Now here is another moment worth reflecting on. In situations involving public officials, officers must remain especially mindful of professionalism, not because the individual holds status, but because the event may later be examined under heightened scrutiny. At the same time, public officials must also respect the legitimacy of lawful police authority. Mutual respect strengthens institutions, conflict weakens them. From my perspective, the most educational takeaway here is this: equality before the law is tested not in theory, but in practice. It is easy to say everyone is equal under the law. It is more meaningful when that equality is demonstrated calmly and procedurally during ordinary interactions, like a traffic stop. Now let me ask you something as we continue this analysis. When public officials are involved in routine law enforcement encounters, should those interactions be handled exactly the same as any other stop, or should additional safeguards exist because of institutional roles? I'm genuinely curious about your perspective. Share your thoughts in the comments. In Part 3, we will examine broader constitutional implications, historical examples of high-profile traffic stops involving public officials, and how courts have interpreted disputes arising from those encounters. If you're finding this breakdown helpful and educational, consider subscribing for more in-depth legal analysis, where we separate fact from assumption and law from reaction. Stay with me, because understanding how the law operates in ordinary moments often reveals the most about how strong it truly is.